protect my green card process during lengthy retrogression. I'm Sam Shihab.
I'm Brian Burke.
And we're from the law firm of Sam Shihab and Associates. When we come back, we're going to talk about various scenarios in which you have to be proactive in thinking ahead in protecting the green card process if there's a lengthy adjudication. And probably this presentation is going to have to be part one. We don't know when part two will come out, because as we were talking about this, there were so many scenarios and possibilities and issues that can come up. So when we come back, we're going to talk about how to protect your green card process during lengthy adjudication or retrogression. All right, so you guys need to understand that Brian had coffee today. He doesn't usually have coffee, so we got to try to slow him down. He was telling me a moment ago that he had coffee.
Coffee, then some sugar. Follow that up with some later sugar.
So there was a lot going on today on your plate.
Yeah, I'm busy day, as Mondays often are. So I think the things that come out of my mouth should be very interesting today.
All right, sounds good. Everybody's looking forward to that.
Yeah.
All right, so this is not the first time that we've dealt with if there is a lengthy retrogression or lengthy adjustment of status. And when we say lengthy retrogression, we're thinking about you may have filed your adjustment of status already, and then it retrogressed, the visa availability retrogressed, and now you're caught in that pool of people who have employment authorization document, advanced parole, I-485, and an employment, and that might be going on for some time. And you have to maintain that employment and your status quo to be able to get that green card when the visa bulletin becomes current again. Yeah. That's what we're talking about.
Yeah, it's, could in theory be a lot of time you have to wait, and what can I do? What happens if things don't go well? I mean, that's the real, we're talking the lengthy adjudication, and there's the economic side. Lengthy adjudication is no problem if the job market is good, but if the economy starting to close its doors, that's when you really hit the challenges there.
And obviously, 2007.
2007 is when they made everybody's priority date, current, and for years people had, I think maybe they were resolved mostly by 2015.
That's a good date. I remember, yeah.
Yeah, so it took around until 2015 before those people who got there, again, filed in 2007, got their green cards in 2015. Sincerely hoping that's not what we get here, but it's a distinct possibility.
And during that period of time, you just need to be vigilant and proactive. And let's dive into it, Brian. And we broke it down into, as we try to kind of go through it in a logical way, for those who have an I-140 approved and an adjustment of status that has been pending for more than 180 days. So those guys are in a great position. And back in 2007, that 180-day thing wasn't available, if I remember correctly. I don't think so.
No, I thought it was just a little bit different. You have to write out a letter. The portability rules were there. I think it wasn't as formalized as it is.
Maybe, yeah.
Yeah.
But let's go. So the adjustment.
So we're talking about something, Sam. Sorry.
Portability.
Yeah, portability. Exactly.
Yeah. So portability is a wonderful tool available to you to move to a new employer for same or similar job classification. Now I'm remembering it was there. Yeah. For same or similar job classification, and you file a supplement J. What do you think about that simple solution? Of course, we're going from the simpler scenarios to a little bit more difficult scenarios.
Easy, as long as you can find another job out there, somebody willing to sign a supplement J for you. Yeah. I know there's a lot of companies out there that are not willing to sign off on, do immigration sponsorship, but a lot more companies, don't find supplement J to be really, distasteful. I've, helped people get supplement Js from companies who I thought, would never touch immigration sponsorship, but supplement J, sure, it just says we're offering this job. That's great,
It's a simple form. There's no filing fee, and they just hand it to you, and they say, good luck. it's accurate.
Yeah, as long as you let your prospective employer know that you're going to need it, most of them are going to be on board for it. So that's that. It's wishy-washy as to when exactly you're required to file it. Do you file it immediately upon changing jobs, or do you or can you wait until asked? Bottom line is the conservative recommendation is to when you change jobs, submit a supplement J.
Yeah, I think USCIS would like to receive it when you've changed jobs. And honestly, if you cannot get it when you change jobs, don't expect the employer to give it to you 6 months later. They're not going to change their mind. So you might as well figure out whether you can get it early and get that out of the way. Okay, so that's adjustment status portability. That's no big deal.
Yeah.
Now, we are, in situations where we may be, Microsoft is talking about layoffs.
Yeah.
Google is talking about layoffs. Elon Musk saying, if I take Twitter, I'm laying off 75% of the workforce. Everybody is talking slowing down in the economy. And the big one is furlough.
Yeah.
So what is furlough?
Furlough, it's layoff junior. It's temporary layoff. It's I describe it as this. Hey there, guy or gal. Go take a seat. Go home. Sit down. We'll call you back when we need you. We definitely will have a job. We're planning on calling you back in the future. Just no work available for you right now.
And we were discussing what does furlough mean for a green card. So let's say your employer, you're working for a big employer, and say, we don't have enough work. Come back in 2 months. Just take 2 months off, and you got a job in 2 months. Is that inconsistent with a permanent job offer?
Well, yeah. So the high level is, you should always have an offer of permanent employment in the United States when your green card is pending, right? However, you go down a level lower, you say to yourself, well, first of all, they have these portability rules that allow for, changes of employer, and, layoffs clearly are contemplated by that. And layoffs are definitely contemplated because they basically provide, you're safe once you've made it past that 180-day mark. So clearly you're allowed to have some periods of, hey, I don't have a job with a pending green card. And I guess there's the less extreme version of, well, all you really have to do is have that offer of permanent employment available for you when that green card is ready for you, right? But that green card could be ready at any time, So there's all these issues kind of to get together there.
So furlough.
So give me an answer, Brian.
Furlough is a temporary layoff, right? And it's problematic.
Yeah.
Because there is a gap within which the employer told you, I don't have a job for you.
Yeah.
I don't have a job for you.
Yeah, and so if USCIS becomes aware of that, that kind of violates that first high-level tenet I mentioned there. You should always have an offer of permanent employment, right? And you can. There's an argument to be made, though. This is temporary. My green card is still waiting for me. No problem, USCIS, right?
So when you apply for, so most of our jobs are based on labor certification.
Yeah, most of our jobs
are based on labor certification. And one of the things you certify when you file the labor certification that there has not been a layoff.
Yeah.
In the job occupation during the last 6 months of filing of this labor certification.
Sure. Yeah.
Okay. So clearly, a layoff in other, not of you, the foreign national, with other people who are similarly situated within the company.
It's a counterindication for immigration for somebody to the United States.
Yes.
You're right.
So for me, if there's a furlough, I would be nervous.
Well, so high level, I agree. You should be nervous, and that sounds like a shaky company to me, at least from your perspective.
Well, people listening to us need to hear an attorney opinion.
Oh yeah.
Okay. Here's an attorney opinion. An argument can be made by the USCIS with an unfriendly administration in the future that we may have, that a furlough in the past is an indication of loss of offer of employment.
Yeah.
And I think an argument can be made by a friendly administration that a furlough alone should not be looked at.
Yeah.
As a loss of employment.
That sounds like the opinion that you and the conversation that you and I have in the office. But if I want to give practical advice to somebody, it's if you have an option, this is not if that's a shaky employer, I would say your best bet is to take advantage of the portability rules and find somebody else because what's the term that you use, Sam? You don't want them to look up, read in the news that your employer has furloughed people and go, I should go talk to whatever government attorney covers our office to see whether that's something that impacts our ability to approve this
green
case.
card. Yes, and the more front runner your company is, cutting edge, your company is, the more a furlough would be in the news. So if you're working for an obscure company that nobody talks about, nobody knows about, in the middle of nowhere, there's no newspapers, even, there's a lot of places there are no Sunday papers anymore. Yeah. And then there was a furlough.
Yeah.
I don't think that is going to be in the radar.
Yeah.
And I would feel a little bit better in a situation like this than a company like, I don't want to mention the company name, but a big company where you'll read it everywhere. And that, I think, impacts.
Yeah.
That has an impact. Okay, so priority dates. If your priority date close or not close, does that make a difference in your decision on portability or furlough or any of those issues?
Well, if your priority date is not close and, I guess, it's less likely if the government's not looking at your case, less likely that furlough is going to come to their attention, less likely they're going to care about it, though you still have a vulnerability there. If your priority date is current and your employer said, hey man, go take a seat, we'll call you back, and USCIS at any time could come knocking with an interview or just a simple request for a supplement J, and then you have some trouble. You can perhaps do some stalling, not on, USCIS has extended their flexibilities for RFE responses, for example, give you another 60 days. But again, if you have the means,
Did they announce it?
They did, yeah.
Okay.
I believe it was today. If you have the means, though, still, it's if you can find somebody who is willing to sign a supplement J for you. If I had two options, stall. I mean, if I was talking to a client right now who said, I'm on a furlough and I have a RFE requesting a supplement J, I said, well, you could kick back and wait for your employer, or you could go find yourself a new job right now. And I'd say, take care of yourself. Go find a new job. Don't put all of your eggs in your current employer's basket because they're broadcasting that they're having an issue right now.
Yes. Well, let's make it more difficult, Brian. What if it hasn't been 180 days since the adjustment filed. So you have not crossed that magic 180 days since the adjustment's filed. And you hear that the employer might be laying off. What would you, now, just remember, we kind of have not gave the disclaimer. These are kind of general scenarios we're discussing. Discuss your specific case with a competent attorney. We and many other attorneys spend a lot of time in the office discussing those scenarios together in a brainstorming to come out with solutions. Mm-hmm. But don't rely on us because we do not know your case. But in the scenario we're discussing here, the hypothetical we're discussing, you hear they're laying off. And it's like, okay, what can I do? Or is there anything I can do preemptively to help myself?
Well, the number one thing we were talking about is negotiate. It is possible for you to, talk yourself out of a layoff. Essentially, keep your, what's most important for you. And employers are often sympathetic to this. It's, hey guys, I'm going to lose my entire green card process if I don't make it past this 180-day mark. Keep me past this 180-day mark, and that's that. And there's employers that are definitely willing, to do that. Once you cross 180 days, you're in the portability zone, and the world is your oyster.
Or you can tell your employer, I know you're going to announce a layoff. I have a green card or a furlough. I have a green card. Can I take a leave of absence and leave the country? I have an advanced parole. Let me leave the country for 4 months, and you don't lay me off. You don't furlough me. There's nothing on my record. And if you need me, I can come back and join you. If not, I would cross the 180 days, which would allow me to port my green card somewhere else.
Now, it's a good idea, but it's still a little bit of a gray area. The government could, in theory, look at that and say, okay, so you left, and everybody else in your company got furloughed, and you were just, went back to your home country and just were hanging out, relaxing. They could make the argument. You still have the same fundamental furlough problem, but basically, I'd rather have some sort of argument than no argument whatsoever.
You have a better chance of arguing it if you're able to negotiate.
Yeah.
You would have a better chance.
Yeah. Bottom line is, make sure your employer doesn't lay you off, withdraw your I-140 until beyond the 180-day mark, and that what facts were on the ground, USCIS may not care about that as long as your I-140 is with, they leave that on the record after the 180-day mark. Again, who knows how individual officers are going to play this out, but you would rather have a leg to stand on than no legs.
The second possibility, I'm sorry, I'm going to lay you off.
It's a business decision.
It's a company decision. You're on that list.
Yeah.
And we're withdrawing all I-140s. And boom. What are your options?
Well, the one that sort of comes to our heads is many of you folks out there have filed multiple I-140s through multiple employers, and it is possible to go back to a prior employer that previously filed an I-140 with you and have them revive it. If anybody's not aware, even if your I-140 has been withdrawn, it can be revived through a new I-140 filing. There's going to be some work by your employer. They're going to have to establish their ability to pay. But it's possible to go back to an old I-140 that's essentially dead, revive it, and suddenly that's your path to a shiny new green card that way. And the people who get employers to sponsor them for green cards in the United States, they're usually pretty special. The bottom line is you pick up the phone and say, well, guys, we did good work together. I made money for the company. Would you like to have me back? And again, it's a business decision. If that company has work that you can do, you can find yourself back with a prior employer. And it's not a hypothetical. It's something we've helped people do in the past, for sure.
And this includes, this is by the way, a real scenario that we had advised a client. This client came and had talked to a couple other attorneys before us, and then talked to us. And his scenario was even worse because he had the permanent I-140 from another company, highly successful, cutting-edge technology guy, top university in the U.S., master's degree in engineering, very bright, works for one of the top entrepreneurs in the U.S., a big name. Okay, and this guy decided to shut down the company. He's just got bored of it, and he has a perm that's still pending, and he's beyond 6 years on H-1B. They're shutting down the company, and basically, when they shut down the company, the perm is not approved yet, so he lost the permanent job opportunity, and he cannot extend beyond 6 years because he was current. His H-1B was his priority date was current. And the way we were able to advise him and help him, and the other attorney, much to our credit, prior attorney that advised him.
I have a different story like this, but similar, yeah.
Yeah, and we told him, you've lost your H-1B, and he's like, what? I did not know that. I said, we cannot even renew your H-1B. So we advised him to go to his prior employer that filed his old perm to revive his I-140 and file an adjustment status.
Yeah, I had dealt with somebody a couple years ago, had come to the United States, had been about a year. He was an L1A guy, so L1A manager, and he was in the process of doing his EB1 I-140, and his employer said, oh yeah, we're shutting down that entire division. And he was kind of shell shocked because basically he was so close to getting that green card, didn't make it to the portability deadline as they took away his I-140, and he thought he was out of solutions, and his solution was, hey, I was in the United States on H-1B in the past, and go revive your H-1B status with another I-140 you had, and there you go. It's always looking back to your past is really something that has worked a lot.
And the other solution that you can do, and something a lot of people don't talk about that, is if you're losing your job and you're losing your adjustment of status, pursue an I-140 national interest waiver.
Oh, that's a great one.
With a concurrent adjustment. If you make a good faith effort, you will have a pending adjustment of status.
Yeah.
And that, by the way, takes a couple of years to adjudicate.
Yeah. And
you can, during that time, find an employer, get a perm labor certification filed if you have to, get that certified, get your I-140 approved, and have a second path towards, and an I-45, file an I-45 if you can, because I would love to be able to continue that H-1B.
Sure.
And have a second path towards a green card. So a national interest waiver, concurrent filing, you can keep things going.
Yeah, the big benefit of the national interest waiver is you can file it yourself without a separate employer petitioner. And if people think I can't qualify, there's policy out there that right now that really favors STEM people for national interest waiver cases. So,
huge, absolutely. Get to know it. Absolutely, and make a good faith. If you find a good qualified attorney that says you have a reasonable chance, then you have met what I would call good faith.
Yeah.
To file this application and file it. It takes 2 to 3 years to adjudicate. That's enough time to be here, get a new I-140, and get a secondary.
Buying time is just so important, Yeah. So one of the things that we just got to talk about, Sam, is what if there's no job offers out there? What if nobody is willing to hire you on a permanent basis? And this is when we talk about one of our favorite topics, self-employment.
Huge.
Yeah.
It works. We've done it, and it saves your green card. We can talk about the nuts and bolts of it. It's not the kind of thing that you can do overnight. It takes time, and therefore, if you feel, and you have to have the sixth sense. Some people don't have that, they just work, and then one day the boss comes and hands them a pink slip, say, sorry, we're laying people off, and you haven't done anything. You come to me, there's not much I can do in this scenario, maybe a national interest waiver possibly.
If I'll entertain it for a second, Sam. If you have no RFE, you have no immediate demand for USCIS to produce an offer of employment.
I like that.
But yeah, you're right. You can actually start a business overnight. I can decide, right now to start up my own company, and I have one
If you're
tomorrow.
in demand, Brian's 100% right. If you're in demand and you have good skills, you can create a limited liability company in 1 hour. And hopefully you can call one of these payroll companies, set up payroll in the next hour, and be in a position to market yourself for jobs out there as through your company for services of same or similar
to your green card role.
To your green card role, and you can do this quick.
Yeah, I mean, USCIS, ultimately, it's real critical to get yourself out there, though, and that's maybe the thing that's hard to do fast. But getting yourself out there is important because USCIS can question say, okay, congratulations, you started your own company. I don't believe you can support yourself. This is going to support your permanent, your permanent role in the United States. I don't believe you have to have the income there. And the argument is, no, show that you have work. Basically get a role through your own company, and that's a way to do it.
I mean, it's all about timing, right?
Yeah.
You get laid off, and you got an interview next week. We got a problem, and there's a lot of work that we have to do in 1 week.
Yeah.
But like you said, Brian, I love a challenge. Number one, I would love to look at a national interest waiver potential application.
Yeah.
Before I go into that interview and have it filed. Mm-hmm. That's number one. Number two, I would love to have a company, and I would like to have hopefully some kind of an engagement or something, and I would like to walk in and present these things. And if they deny, I'll file a motion to reopen and reconsider, and I can appeal it.
Oh, yeah.
And there's all kind of things.
All these things I say, and if you know anybody who's hiring for W-2s, go for those interviews as well. You're going to have a full-time job for the next week.
Yeah.
It's going to be promoting yourself.
Yes.
But again, I always want, in anything I do, Sam, I always want to go down swinging.
Absolutely. No, there's a lot that can be done, but you're going to have to be aggressive. So a lot of time, here's what happens. I get cases, something happened to their case.
Yeah, I have a case in
Okay,
mind. That
and they meet with the attorney, and we say, okay, yeah, no, it doesn't look good, but all right, we see a path. Not guaranteed, but we feel good about it. But we need to do 1, 2, 3, 4, 5. And then people get overwhelmed sometimes, emotionally overwhelmed. And that's the piece. I don't know if I should just leave and go back home. I've been here for 10 years. I'm just tired of this process. I understand it. I'm tired of this process. My wife and I are really exhausted, and we just don't want to fight it anymore. Okay, I understand. But this is not going to be the only challenge you're going to face in your life. You're going to face other challenges in your life. I don't care where you go. You go back home, you go there, you go here. There will be challenges. And you just got to, take them on. And if you trust your attorney and the attorney tells you, I think you have a decent chance, I think you should take it.
Yeah. Yeah. I mean, nobody's going to give you a guarantee, but I think I know the guy who's in your head right now, and it's just there's somebody who we could have kept in the United States working longer, and we could have there's a reasonable chance that person could have seen a green card, and the only reason he didn't get one in the first place is because USCIS didn't treat him fairly. And as an aside, there's an inherent unfairness in the immigration system. Perhaps if they got into this, his case about 10 years earlier. But yeah,
if there's a will, there is a way, and. Between Brian and I, we have many years of practicing and many stories to tell, and we can tell you stories forever. But the bottom line is, we've seen these work. Yeah. We have been part of the process, and many attorneys, experienced attorneys, if you trust them, they tell you, we have a path. You should take it.
Yeah,
you should
that's sometimes I've encountered people who are just kind of hesitant and kind of lost. One comes to mind. I gave him some advice, and it took him a while to actually do it. And I hadn't heard from him, but a couple months later, I said, I get a call and say, I didn't believe you. I didn't think it would work, but I talked to a company who was willing to sponsor me for a visa, and they said, no problem, and I'm happy.
That's awesome. Absolutely, that's wonderful.
Yeah.
If I travel,
yeah,
and I get the call, I am outside the country, that I got laid off, I have an advanced parole.
Yeah.
What would you do?
Well, you can definitely come back to the United States, because as we sort of discussed earlier, even though the high-level principle is that you're always supposed to have an offer of permanent employment associated with your adjustment of status, practically speaking, the rules allow you to change employers, allow you to have lapses. So I don't see any problem with you coming back pursuant to an advanced parole if an employer says they're going to withdraw your I-140.
Immediately come back.
Yeah.
Immediately come back to the United States and immediately pursue the options. Self-employment, for example.
Yeah.
You can come back. You can initiate, if you have a relationship with counsel, you can initiate setting up your corporation in your company as you are sitting on the plane, as you're flying back to the United States. You land as a self-employed I-485 applicant.
Yeah.
And no problem. Absolutely.
Yeah. So I don't know if this is exactly related, Sam, but I often get the question, well, how long can I stay abroad with my I-485?
Without a job.
Yeah.
With a job or without a job?
I mean, ultimately,
with a job is easy.
Well, here's the thing. With a job, with no job in the United States, if your employer sends you abroad saying we don't have any work for you in the United States, you have a problem.
No, you're working remotely, let's say.
Working remotely, there's kind of no limitation. If you have a hard job offer of permanent employment in the United States, you are not a green card holder yet. You can stay out there indefinitely. If you don't have a job offer, either of these scenarios, Sam, you have a job offer, I think a USCIS officer that's ready, if they're aware that you're outside the United States for a long amount of time and they're getting ready to approve your green card case, or getting ready to look at it, a long retrogression, you've been outside the country for a couple years, and your priority date's up, let's make a decision on this. I think they'd make that awful noise. And I think they'd start issuing that RFE requesting a supplement J, and that was something, we wouldn't, in the oldest times before supplement J existed, we wouldn't get supplement J RFEs, but we get letters saying, hey, please let us know you have an offer of permanent employment in the United States, and that gets you back to the United States quickly. That's for sure.
Also, with self-employment, you don't have to have a single full-time job. You can have 6 part-time jobs.
Yeah.
You can take 6, 7 assignments. Each assignment is 10 hours or 8 hours, and keep taking assignments. And you can show the totality of the work you have is full-time through your company.
Yeah, obviously, for the purposes of having a green card, the green card offer employment should be offer of full-time employment. But if you have one company that says, well, we can offer you, 20 hours a week, another company that says we can offer you 20 hours a week, your company can smash those together into one offer of employment if you have your own company.
Or a series, and then you're signed up with some of these entrepreneur, freelancer websites, and you're getting constant business.
Yeah.
You can keep that going, and you can show that I'm keeping myself 40 hours or more a week busy every week through my company. You can definitely make a strong argument.
Yeah.
Anything else to cover, Brian?
No, I think that's kind of what we wanted to hit in this.
Okay. And like I said, we're gonna come back and revisit this. There's so many scenarios that we can discuss that will come up as we hopefully not see a lengthy retrogression, and we will share them with you. And we'll be back to answer your questions.
Alrighty, Sam, we're back.
So this is the part of the presentation, or the time of our presentation that we answer questions. And just remember, there's few ground rules that we have. There is no attorney-client relationship established by you asking us and us answering you. Keep in mind that these are general discussions. We are not 100% familiar with the facts of your case. Actually, we're absolutely not familiar with the facts of your case. And therefore, our answers are very general in nature. And always consult with a competent immigration attorneys to advise you to make decisions on your case. And without further delay, let's take the first question. Yeah.
So, from Ganesh, my priority date August 2014 on TN visa. My wife's TN expires in 6/23. If I can't get EAD by then, can we ask to expedite EAD as she will lose her job of 12 years? My parents are very old. Can I ask for expedited AP?
What are the general rules on expedite?
But it's a pretty high threshold to meet, for one thing. However, let's see here. Here's the grounds that offer expedited processing. Let me see here. USCIS error. Humanitarian concerns or massive financial loss, and just losing a job is not really good enough for them for financial loss. Those are really the highlights. U.S. government interests as well. So, however, anecdotally, I have heard that a lapsing employment authorization that you cannot extend is a time that sometimes USCIS has been willing to expedite green card EADs. So, if you have no other option, it's certainly worth a shot. Again, this is the United States. Nobody really punishes you for trying,
Yeah, and it's highly technical. Go through a counsel of your choice to advise you on how to do it, or for them to do it for you. We do a lot of these for clients, and we can tell in advance after we get the facts. We just tell them up front that this is a decent case or this is a bad case. We've had cases where expedited processing worked.
Yeah.
We've had cases where expedited processing didn't work, and we've had cases that they should work but didn't. And so I would categorize your case into the possibility, but not high possibility.
Yeah, I mean, the devil is in the details as always.
Yes.
You know.
Yes.
You know, Sam. There's a second question on that one. You know, my parents are very old. Can I ask for an expedited AP? And again, you know, when people are in ill health, that's something, you know, that USCIS might consider being a humanitarian concern to grant.
They typically need a letter from the doctor to show the grave nature.
Yeah.
It's just general ill is not going to do it. And you have to make a special appointment to the local office and go for a personal interview to present these documents to.
Yeah, it is upsetting. You know, I mean, they should be approving these things faster. And the question, so my relative has to be dying for me to visit them, and unfortunately, that's the answer we have to give sometimes.
Yes.
Yeah.
Harry, thank you, Sam Bryant, for a genuine cause about the retrogression and how they handle the application for the past 2 years. Myself and my family.
Spouse and 2 kids, 19 and 16. Yeah.
19 and 16. Applied for adjustment status in August 2021. Final action date is current. Prior date July 2013. I'm with the same employer who did perm. I'm 40. What happened to my kids' adjustment application when they?
And here it is.
When they turned 21, a couple of years. If we did not have our adjustments approved, FYI, when we submitted, the kids' age was 17, 15. After was first submitted, our adjustment status was final, action date is current. So to me, it sounds like they're locked.
Yeah.
I don't have the specifics of your case enough to say that but you appear to me that the kid's part appears locked. Final action date is current.
Yeah.
Right?
Yeah, a current final action date with approved I-140, and as long as you stick with that I-140, don't go moving them around. Generally speaking, yes. However, you know, Child Status Protection Act is very, very, very fact sensitive. If you're concerned, you know, that's the thing when you talk to an attorney, you say, hey, I want to understand the Child Status Protection Act on behalf of my kids. But, you know, your priority date is current in the EB3 category right now. I'm still optimistic. What did it say?
2013.
2013?
Yes.
We can get there.
So that's one thing. The other thing is, remember, as your children cross 21, the moment a child, well, they're over 21, they're not children, but they're locked in, potentially, we hope. But if they're locked in and if they get married, they're no longer children, so they will not adjust. So they must stay single. That's really important.
That's a very good point. Yeah.
Yeah. So that's very important. So something can I share with you? But yes, hang in there.
So basically, when even though your kid, you know, your child could in theory be locked in under the CSPA. If they get married, they put themselves outside the definition of being a child under the immigration laws, meaning they're unable to get a green card through you.
Yes. So the children under the scenario, if they're locked under the Child Status Protection Act, the adjustment status remains. They get EADs, they get advanced parole, they get to travel, they get to stay in the state until such time the green card is current. The priority date is current and the green card is processed. Yeah. That's the answer to the question. Any news, update, thoughts on immigration reform or registry bill? It's an election time. Nobody talks about immigration now. It's a hot topic, controversial. Nobody's going to agree. Nobody's going to give the other party a victory. It's not going anywhere.
So on immigration reform, you know, about this time last year, we were very, very excited and optimistic about what was going to happen. President Biden, as part of his Build Back Better Act, haven't said that one for a while.
And Manchin destroyed
Manchin and Sinema, I think, and mainly Manchin, I guess, were basically shot that apart. And you're right. Maybe if the Democrats, get more than we think they're going to get out of this election, maybe they have the majorities they need in order to do something. Maybe you get immigration reform. The registry bill, a version of one was circulated recently, and we talk amongst ourselves about what to talk about here, and we were wondering whether we should talk about that. And you sent it to me and said, "What's your thoughts?" And I said, "Dead on arrival."
Yeah. Yeah, unfortunately.
Yeah. That's the end of Hari's question there.
Yes. Yeah. All right, take that one, Brian.
We already hit this one. Must be a repeat.
Yeah. My project is April 6, 2012 in EB2. Will I be current in the next 3 months? 6 days.
Yeah, that's really, really darn close.
Yes.
I think there's a pretty darn good chance. Nobody can guarantee anything, but there's a pretty darn good chance of that.
Yeah, yes. All right, so Rajay Singh, 45 EB2 pending for 180 days. Project April 2013. I am moving to my previous employer with whom my I-140 EB1C was recently approved. Wow. Should I file new I-45 EB1 or interfile? EB2 I-45 with EB1 I-140. So you get two options. You can interfile or you can file a new adjustment of status. Which one would you prefer?
I don't think anybody who says they have a definitive answer for this one is really can say that truthfully, because if you file a new I-45 EB1, well, that's a shiny new case, and you leave intact your EB2 adjustment, which could be current.
I have an opinion.
You have an opinion?
I have an opinion. Second adjustment, because this 2013 priority date, there's a lot of time passed on it, and why would you just walk away from it?
Yeah.
You never know.
I don't want to give that. Yeah, I don't want to give that one up.
Yeah, you never know.
I am always in favor of maintaining as many possible paths to a green card as possible.
I'd file a new. I would file a new.
Yeah.
I mean, but you can make a good counter argument.
Yeah,
again.
arguably the work you've done on that on the previously filed I-485 is good. It will get your EB1 case to approval faster. But we all know they don't process tubs transfer of underlying basis very quickly. So
we struggle with these questions just like you when there's a judgment call, because unfortunately we deal with a system that has more gray than black and white.
Yeah.
And that's a great question. I don't want to give up a path.
Yeah.
I just don't want to give up a path.
I mean, I can imagine two people, exact same scenarios, and they do, and both of them do the same thing, and one of them gets, a green card, immediately, and the other one gets, a nightmare of pain.
Yeah.
Because USCIS is sometimes a nightmare in terms of doing these things.
Yeah.
Again, I generally favor though keeping as many paths to a green card open as possible.
Yes. Hello, Mr. Fear T. I got my EAD advanced parole in EB3 in 2022 February after filing in October 2020, prior to November 2013. Spouse is going to start using the same around November 2022 for work, moving from H4 EAD. Meanwhile, husband is planning to apply for EB1B soon. Would it cause any issue, any hope of EB3, EB2 prior date November 2013 getting current in fiscal year 2023? So basically the wife is moving to EAD. He is planning on applying for EB1B. For me, planning doesn't do anything for me in evaluating the case.
Yeah.
Good luck. I don't see an issue. I'm assuming your job is stable.
Well, so here's what I kind of see. So if she uses this her green card EAD, leaves her status behind, in order to get let's assume that the EB1 green card is going to come faster, and there's a reasonable chance it might. She's abandoning her ability to file an adjustment of status through her husband. It's a new adjustment of status. So the only way she's getting into the EB1 B category is to transfer on underlying basis, which is
She has two paths. She can do a transfer underlying basis, right? or she can do a new I-485 within 180 days of stepping out of H-4.
This is true.
But Brian raises an excellent point. And what Brian is saying is that the path for adjustment filing for your spouse and children will narrow a little bit. It's not impossible at all. I mean, transfer or... So look at that before you jump on the H-4 EAD. Discuss it with a competent attorney and understand it and make a decision.
Yeah,
that's what you're
that EB1, that filing for EB1B soon, that case isn't approved until it's approved, and I would rather have multiple paths to a green card.
Can I port from computer software engineer to IT director? Thanks. So the devil is in the detail, but when you say port, you're talking about AC-21.
Yes, supplement J portability after your adjustment status has been pending for more than
I would
80 days.
want to, it's a big leap, I'm going to say that. I would want to look at both job descriptions to answer you, because the titles are not what decides the success of the same or similar. It's what the job description is.
Yeah.
But if it's a super low computer software to a super lofty IT director, I see potential issues. But let's assume an advanced computer software engineer job description with kind of a small company IT director.
Yeah.
If you're an IT director with Google and you're a software engineer with a consulting company, it's a problem.
Yeah, I think of like the
But
scenario.
if you're a software engineer with Google and an IT director with a small company, it may not be a problem.
Yeah, I think of this scenario like, what if it's all with the same company? If you filed with a computer software engineer with your employer, and now they want you to be an IT director, that's when I worry about getting the from the USCIS officer. So you filed 6 months ago with this company saying it's going to be a computer software engineer, and now they want you to be an IT director.
Sounds like a new labor certification.
Yeah.
So yes, the devil is in the details. Yeah. A lot of those are problematic. Some of them might not be.
Yeah.
But more problematic, you would say, if you have to weigh it without knowing more.
Yeah. I mean, it's possible to do this one, and if you read the portability policy, they explicitly state that you can move to a more senior role within. But it's just to a managerial job codes. It's just the devil is in the details. Yeah.
Does EB2 National Interest Waiver need supplement J? There's no offer of employment required, and that is not a requirement for National Interest Waiver.
Well, so my honest answer, and this is where I admit I'm not the fount of all immigration knowledge, is I would go. I think it's sounds like somebody's maybe in the scenario of somebody filing an I-485.
It's not needed. It's not required.
I don't know. I think I would want to go read the I-485 instructions, because their general rule for I-485 is if you're filing with the I-140, you don't require a supplement J. If you're not filing with the I-140, you need that supplement J. I think even though it's a silly supplement J, it's saying I plan to offer myself the same job that's on my I-140. I think that's a silly supplement J, but whether it's legally required, I think I'd say, and I'd go review the instructions on the I-485 form.
Okay, let's do that. Maybe we can post something for TA.
Yeah.
My priority date is April 21st, 2015, EB2 from India. My chances of final action date getting current this year, ?
April 21st, 2015, EB2, India. So, as a reminder for everybody, for EB2, India.
April 1st, 2012.
Yeah, we're April 1st, 2012. So, we have sort of done our analysis on the subject previously. Right, and we said that what USCIS was saying in these court cases, yes, there's plenty of, the rest of the world demand is so low, there's tons of visas available for India EB2. That's what they're saying in August and September. They're saying rest of the world demand is so low that we're going to allocate more to India EB2. But on the end of the visa bulletin and on the last couple of visa bulletins, they said retrogression, and the most recent retrogression, the most recent visa bulletin, they say rest of the world potential retrogression. It decreases the chances, our prospects for seeing April 21st, 2015. That's for sure. We will kind of know whether what USCIS is saying on the end of the visa bulletin, or Department of State says on the end of the visa bulletin, has any teeth when we see the first quarter of the fiscal year come to a close, and January, perhaps February visa bulletins, if we see any actual movement.
And also the I-140 filings shows heavy filing.
Yeah.
And which was surprising to us.
Yeah.
We do not know where these are coming from. Hopefully they'll revise them and correct them. So up in the air, we need more time. Time will only tell.
Yeah.
All right, so Sanjeev, prior to date 2014 in February, received EAD and advanced parole in January 2022. Submitted an RFE with I-693. Currently, status fingerprinting were taken, and it is in field office. What is going on with my case, and when can I expect my green card, Mr. Brian?
Well, I know exactly what this person's case looks like. I was just happened to be in a USCIS field office last week, and it's in probably a brown folder, about yay high, and are they doing anything with it? Okay, are they doing, sorry, I got off on a tangent. I told you I was going to say some interesting things. So basically, what we've been hearing is that, USCIS is still seems to be working on cases, despite the fact that you don't have a current priority date for them. Is your case in that field office? There's probably a pretty good chance it still is. When are you going to get your green card? Well, the question for me is, when can you get your green card? And you can get your green card when your final action date is current. And for February 2014, I like it a little bit better than April of 2015 that we saw in the last question there. But USCIS, everything that we saw at the end of the fiscal year seemed to point to them being able to get through the backlog they have. But, they're really kind of bludgeoning my optimism with a hammer because, again, here it is, backlog.
Ramanath V. My priority date is January 2013, and I received EAD and advanced parole. I've traveled to India and enter. If I've traveled to India and enter as a parolee, what happened to my H-1B, one of two? Let's talk about what happened to your H-1B. So the departure on an advanced parole does not terminate your H-1B status, and when you come back and join your H-1B employer and file for an H-1B extension, the approval of the H-1B extension acts as termination of your parole status and reinstatement of your H-1B status in the U.S.
Yeah, that's a policy. When you enter with advanced parole, you are a parolee, but if you extend your H-1B, they terminate your parole, put you back in H-1B.
What would happen to my EAD and advanced parole when I apply for my H-1B extension in October 2023? They're valid. They're perfectly valid. 2023, probably you're maybe around time you may have to renew your EAD or advanced parole, but nothing happens to them. They're available for you to use one more time.
Well, if you're not, yeah. So I guess I just want to point out that, use of the adjustment EAD and AP, they are like oil, and the H-1B is like water. If you're using those things, remember, you're never going to be on invalid H-1B status. They're just incompatible.
All right, so Harsha, thank you both. Assuming there will be only 28,000 green cards available for India in EB2, what would it take to get 10 years to my green card with April 2013 priority date? Well, that's a good question. And the math, I know there's a lot of people talk about there's going to be 90 years and it's going to take 100 years to get a green card and all these projections, but these are mathematical projections. These are not practical projections. People who got the green card today had a priority date of 2012 and 2013 and 2014, which tells me it's taken 8 to 10 years.
Yeah.
There's a lot of pressure to changing the law and making things happen differently and so forth. Ultimately, I think what we have seen and what I've seen in the last 20, 25, 30 years is that people get green card within 8 to 10 years if you are from India. If that is not materializing, it's self-correcting because people will not come here, will not come to this country. And when people don't come to this country, we will lose our competitive edge. And when we lose our competitive edge, we fall behind. very simple. And therefore, whether the Congress likes it or does not like it, or the administration like it or does not like it, if they don't move these cases, we will get behind in the world, because India is the major supplier of information technology and engineers to the world right now.
Yeah.
And therefore, I think it's self-correcting in my opinion, but that's a philosophical answer.
No, I mean, it is a answer on the ground, because, I talk to people who are, going to Canada. It is exactly what you say. It is a brain drain from here, that's for sure.
All right, so take that one, Brian.
From Sumanth, excuse me. We married in 2002, and we don't have a marriage certificate for employment-based green card. We submitted our marriage certificate from Atlanta based upon our passport and affidavits, invitations, photos of children, because we didn't get non-availability of marriage certificate. So is there a follow-up here? What alternative documents can you submit to USCIS? So that's assuming maybe there's an RFE here, maybe there's not. So anyhow.
So what happened? I'm sorry, I need to go back here.
Yeah, I think maybe there's a missed part of a question. But the bottom line is, it sounds like there's a couple that married in 2002 and doesn't have a marriage certificate, and they applied for their employment-based green cards, and they gave all sorts of other documentation, like passport, like their passports, affidavits, invitations, photos, and children.
Marriage certificate is marriage certificate, but there's something in the U.S. called common law marriage that you could be. Very few states now follow it, so this is a very outlying solution. This is not a mainstream solution. But if you happen to be in a country, in a state that recognizes common law marriage, and you held yourself as husband and wife there, you could be, in the eyes of U.S. law, to be married, by the way. Discuss that with your attorney.
Yeah, I mean,
but unless otherwise, you really need the marriage document.
Yeah, if people aren't aware, in the Department we don't tell you what you need, and USCIS doesn't even tell you what you need. Who does? The Department of State does. They have something called the reciprocity table, where they explain, here's what we expect to see for documents from a certain country. And USCIS will if they ever want to ask, they will ask about, if they don't think they have what they need, they will ask you about it, and they will tell you what they expect. But odds are that you're going to need that certificate or a non-availability certificate. It's never too late, though.
Yep. The Great Invisible. I like the name. Give him one of those claps for the great name.
Yeah.
All right. Turn that off. If my sponsoring employer is paying me less than the prevailing wage, can I leave the employer? I have my green card already. Yes.
Yeah.
Simple. Simple. Momo Lee. Hello. Can you please explain how someone can self-employ if I-45 is denied? Another scenario, can a spouse with a green card EAD start a company and the primary work for the company with new H-1B? Is it possible? Well, if the I-485 is denied, there is not much to do.
Yeah, I mean, I would, entertain the idea for a second in my head. You can't, yeah, exactly. When the I-485 is denied, I think the I-485 is denied, and you really have a problem. Self-employment is not really saving that scenario.
And I mean, is there H-1B time left? I would say it's more difficult to work for your own company's H-1B or for a company owned by your spouse if you're the only employee, because the I-485 self-employment is in the policies and in the regulations now. So that's recognized as an option. Whereas H-1B working for really practically yourself or your wife is difficult, very difficult to do.
If this is a real scenario where somebody's been denied an I-485, that I would say talk to an attorney immediately and basically, look to the details of, if the denial can be attacked on legal grounds, because that's really where,
Hi Sam, any chances for EB3 August 2012 India becoming current in the next 6 months?
I don't know. I think that's a reasonable chance of that, Sam. We're in April. That's only 4 months away. I don't think it's so crazy. My mind's not gonna be blown by that prospect. I think it could happen. It remains to be seen whether or not what they're saying on the end of the visa bulletin comes to fruition.
And the last one, Chris Sams 1. I'm working remote, different from work location. Does H-1B 50-mile rule still applicable even on EAD? Can I change my address in all records, DL, tax returns, etc., or do I need to amend my H-1 LCA? Well, if you amend your H-1 LCA, you got to amend your H-1B. That's the law. Yeah. There's no such thing as 50-mile rule. People talk about 50-mile rule. It's kind of a, I think it's the within reasonable commuting distance.
Yeah.
So if you're working within reasonable commuting distance of your H-1B work site, you may not need an H-1B amendment, provided that you have posted 2 postings at your home required to comply with the Department of Labor, or for the employer to comply with the Department of Labor regulations.
However, I see something in that question, Sam, that gives me an alternative.
The EAD.
The EAD. Again, if you're using an EAD, that is incompatible with H-1B status, and the H-1B rules aren't applicable to a green card EAD. Meaning that's that. Meaning, if you don't want to maintain your H-1B status, that EAD allows you to work for anybody, anywhere.
So if you, yes, an excellent point, Brian, at 7 o'clock. And if you are on EAD, not working for your H-1B employer, then none of these rules are applicable. But if you're on EAD working for your H-1B employer, then you're not on H-1B. You have to decide which one you are on, H-1B or EAD.
Oh yeah.
And that's probably, you don't seem to be clear whether you are on EAD or H-1B, or you're probably not sure. And that's going to be reflected on your I-9 with the employer, whether they listed your I-94 H-1B on the I-9 or they've listed your EAD card on the I-9. Yeah. With that, thank you guys for listening to us. We will come back next week with more pressing issues that we can discuss.